On Tuesday, June 25th, the Karen Read trial concluded substantively with day 31. On this day, the jury heard closing arguments from both sides, delivered by Alan Jackson for the defense and Adam Lally for the Commonwealth. There was a little bit of concern at the beginning of the day as yet another juror was excused, bringing the jury count from 15 to 14 now. But after that was over with, the jurors who were left heard an hour from Jackson and an hour from Lally for their closing arguments. Then 12 out of those 14 were picked to ultimately be the final jurors and were sent into deliberation. At the time of filming this recap, the jury has not yet come to a conclusion, so they will have to come back once again in order to come to their conclusions through the deliberations. But looking at these two closing arguments, there really is no comparison between the two. Alan Jackson is a masterful trial attorney, and his closing argument was a beautiful showing of his art. I know that I've been giving a lot of glowing remarks about Alan Jackson throughout this entire trial, but I'm just calling it like I see it. Adam Lally, on the other hand, did make a few good points, but overall, in my opinion, he struck out on this one. And make no mistake, at the end of the day, regardless of the two closing arguments, the verdict is going to come down to the evidence and what the jury found to be most compelling. But the closing arguments are very important because it's the lawyer's final chance to connect with the jury and arm their supporters with their best arguments from the evidence. So, what came out during these closing arguments? Let's get into it. So before we get into the closing arguments, and because this is my final recap for this trial, I wanted to first say thank you so much for joining me on the journey of this trial. And what a ride it has been over the last couple months with you all. Going into this case, I really didn't know how I felt about how this would even end up. I knew Karen Read's legal team were very high-powered lawyers, but I didn't know them well enough to know what their style would be and if they would resort to being flashy over substantive. And to be clear, when I heard about their arguments initially, saying that she was framed by the local police and by a social circle of friends, I was a little bit taken aback. Those are some very serious allegations, obviously, and it's much easier to claim them than it is to prove them. But of course, as we know, allegations are just that, allegations. And the fact that the state has brought those allegations does not mean that the defendant did, well, anything wrong, not unless they have the evidence to actually back it up. So this trial for me has personally felt like a process of unwrapping the layers of an onion to find out what's next, what is underneath the next layer. And what has resulted for me personally is that I've reached the conclusion that I don't think Karen Read ever hit John O'Keefe with her SUV on the morning of January 29th, 2022. The physics and the math and the science just don't back it up, and so that's where I've landed. This has been an incredible journey, and I am so grateful to have traveled along this path with you all. This community on this channel has been growing into such a wonderful place for people to exchange ideas and thoughts and perspectives, including when they differ from one another. And I love the fact that, for example, when we poll the chat every single day during these live streams to see where people lean as to the charges of the case, it's not 100% to any side. It has been overwhelming to one side on this particular case, but it's not unanimous. This shows that this is a community that is a welcoming enough place for people to join even when they disagree with the majority and when they disagree with me as well. This is something that I've always aimed to achieve, and it's especially great considering the fact that I know that sometimes I can get a little bit spicier with my commentary as the hours of long trial live streams wear on. So all of that is to say, the last couple months have been a wild ride, and I'm so grateful to each and every one of you for watching and commenting with me. And I hope that you can continue to join us on the channel and in the community for the other upcoming trials that we've got planned and for other one-off topics that we will have in store for you here. And with that, let's get into those closing arguments. Now, before I get into the specifics of these particular closing arguments, let me first walk you through some of the basics of the closing argument in general. Remember way back on day one, I indicated to you that the opening statements and the closing arguments are basically a bookend to one another. They are the two biggest opportunities for the attorneys on both sides to communicate and connect directly with the jurors and to try to frame the minds of the jury to think of the case from their perspective. And I always remind people that it's opening statements and closing arguments. This is because you're not allowed to argue in opening statements. However, you are allowed to, and you're highly, highly encouraged to argue during closing arguments. And why is that? Well, it's because nothing the lawyers say can ever be used as evidence for the jury to consider. And so in order to argue either way, they can't make up things themselves. They have to use evidence to make those arguments. And generally speaking, there is a very specific process for admitting evidence. It's usually done during each side's case case in chief. So because the opening statements happen before anyone's case in chief, there's no evidence, so neither side can make an argument off of any evidence. So that's why an opening statement is just that, a statement. It's where the two sides give a roadmap of what the jury will see at trial, and that means it's basically a bill of promises to the jury. Ultimately, the big promise is, by the end of the case, the evidence will show you that the way that we see the evidence is the real way. It's the truth with a capital T. And so now when we look at it from the vantage point of the closing argument, we can now ask, did the two sides keep their promises? Or maybe a better question is, which side did a better job of keeping their promises? And the best way for each legal team to do that is to mirror the opening statement just enough to reference back to it, perhaps, while they draw in all the evidence that supports their side and package it into a cogent argument that connects all the dots and basically ties it all with a beautiful red bow. And the reason for this is, as the attorney on either side, there is a good chance that on either side of this case, you may also have at least one juror that is going into deliberations ready to fight on your behalf. And so you as the attorney want to arm your supporters with the evidence and the arguments so that when they go into the deliberation room, they can keep advocating for your side. This is why connecting to a jury can be so important. If throughout the trial, they have not connected with you as a human at all, and if you've bored them to death or confused them with the way that you put on evidence, you're much less likely to end up with someone on the jury who is a very strong supporter. But let's assume in this case that there is at least one person at this point who is leaning towards the prosecution going into deliberations, and let's assume that there is at least one person leaning towards the defense. On either side, you want to serve these points up as clearly and concisely as possible so that they can re-serve it up to their counterparts during these deliberations. And so when we're watching closing arguments, you have to ask, what are the main points that each side made? And what is the most important thing for us to consider here for either side? So with that, let's talk a little bit about the defense argument since they went first. Now, to be clear, it is a bit of an oddity to me that the defense goes first in Massachusetts. Usually, in my experience, the prosecution goes first, and the reason for it is because they have the burden of proof. Then the defense gets to go second, and because the defense has the luxury of responding to everything that the prosecution has just said in their closing argument, the prosecution can also reserve some of their time initially for rebuttal to the defense. But here, it's the same reasoning, the prosecution having the burden of proof, but with a different conclusion here, which is that the prosecution having the burden means that they get to go second. It's very strange to me personally, but some jurisdictions just do it that way. Anyway, so Jackson got up first, and right away you could tell that there was a theme to his closing argument, and it was look away. When Jackson said look away, he meant that this was basically what the prosecution was telling the jury throughout the trial. Look away when we get called out for showing you an inverted salary report video, for example. Look away when Trooper Proctor gets caught in 4K with his text messages about Karen Reed that are disgusting and disparaging and dehumanizing, and that also show that he didn't investigate the case properly by looking into all of the people involved. And the thing is, Jackson was so poetic with the first part of his closing. You could tell that this was an oration that he wrote very specifically. Every single word choice was meticulously selected and then delivered with precise rhythm. It was so poetic, I almost wanted to hear like a beat played underneath it.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs. Magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way.
So as you can see, Jackson here is referencing so many things that came out at trial in rapid fire succession, but he's not really naming specifically what they are, not yet anyway. If you haven't been watching every day, you might not get all the references because they're essentially Easter eggs that Jackson is packing into the beginning of his closing argument. But rest assured, the jury has been watching, and unless they have been asleep, which the judge would have noticed and would have called a recess so that they can wake up, they're going to understand these references, I think. And so this is a very poetic way of doing it, but what Jackson is doing here is tagging all of this evidence and all of these things that came out at trial and folding them into his argument in the very beginning. Look the other way is what the prosecution and all the witnesses for the prosecution are telling you when these weird things keep coming out during the trial. And so basically what he's saying is if something smells funny to you and you feel like you've been lied to by the other side, you're not imagining it. They've been lying to you. And so he spent the rest of the hour going into more detail about all of these things and pulling out specifics from the evidence to show that the Commonwealth was lying to the jury and that Karen Read is innocent. For example, he was able to make the defense's third-party culprit argument, and he pointed to Brian Higgins specifically. He referenced a timestamp in the Waterfall Bar and Grill surveillance footage where he invited the jury to take a closer look at a weird interaction between Brian Higgins and John O'Keefe. It apparently looks like Higgins was trying to draw John into some kind of a conversation. And you can also see Brian Albert pulling at Higgins' arm like, hey, come on, knock it off. Jackson then lined this up with Higgins' flirty text to Karen where he said, well, and as Jackson described it, what about me? Jackson also referenced the weird butt dials between Brian Albert and Brian Higgins and the 22-second phone call that Higgins says isn't long enough for a conversation.
But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe?
And Jackson also suggested the possibility of how John could have been killed at 34 Fairview Road. He said something like a push, a shove, and a fall could have happened very quickly once John arrived at 34 Fairview Road. And pro-prosecution people might look at that and say, well, that's just speculation. He hasn't proved that that's what happened. But the thing is, the jury instructions that were read in court after the closing arguments say that if there are two or more reasonable explanations for something that happened, then the prosecution has not met their burden. And so again, the defense doesn't have to prove anything. All they have to do is present one or two alternative explanations for how something may have happened and present them in a way that the jury finds reasonable enough that they say, this could be just as likely as the prosecution's theory, and that would be enough for acquittal. Anyway, one thing that was a huge light bulb moment for me personally during this closing argument was when Jackson pointed out that the evidence admitted during this trial included Karen Reed's call logs, showing that she had called John O'Keefe 53 times after she dropped him off at 34 Fairview Road. I was not aware of that number before this moment, so that revelation for me was massive. I was already skeptical of the idea that Karen's 8 voicemails left on John's phone were consistent with someone just having murdered him. But finding out that she didn't just leave him 8 voicemails, she called him 53 times, just further confirmed that belief for me. Now, Lally also referred to the same 53 phone calls in his closing argument as well, but he basically said, well, Karen called John O'Keefe 53 times, but she never called 911, and that's what someone would do if they were really looking for someone. As if to say, those 53 phone calls to John's phone were to cover up her tracks. She knew exactly where he was because she had left him there. But if I were thinking about somebody who was covering up their tracks, I don't know that they would call 53 times, maybe 3 or 4. And the voicemails would be much sweeter, like, hi, honey, where are you? I love you. I'm worried about you. Please call me back. But 53 phone calls suggest something very, very different, either panic or anger or something along those lines. But to me, those 53 calls were 53 angry calls and 8 angry voicemails accusing him of cheating on her while she was looking after his kids. And my big question is, why would she do all of that if she thought that he was dead, or if she was covering up from tracks from having killed him herself? Anyway, I also want to point out that during his closing, Jackson also used 2 visual slides. Now, I personally love visuals. I think that they can help tell a story in a way that holds the attention of the jury and locks them into your perspective. It's one reason why, even in these recaps, which I try to get out as quickly as possible, I try to use B-roll footage and graphics and clips when I'm referencing things as much as possible. But I also know that some closing arguments will over-rely on visuals too, and so you end up with basically this death by PowerPoint. And in this case, Jackson is engaging enough that it's fine that most of his closing doesn't have visuals to accompany him. But the ones that he did use were helpful. The visuals he put up on the screen were a slide that showed Karen Reed's taillight at different points. And clearly this was to highlight that before Canton PD and the Massachusetts State Police got their hands on the vehicle, the taillight was damaged, but not by much.
Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barrows walked into this courtroom. He's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades.
Then in Jackson's closing, there was a bit more about Trooper Michael Proctor then erecting a tall blue wall that no one can scale. And he also referenced Courtney Proctor's text with Trooper Proctor, referencing Julie Albert wanting to get him a gift for his work in the investigation and things like that. But then Jackson eventually ended his closing argument with what to me is the most important part of the defense's argument. And that is his focus on the fact that none of the testimony, whether it be the medical experts or the accident reconstructionists, none of it supports the idea that Karen Reed hit John O'Keefe with her SUV. He highlighted the fact that Dr. Scorti-Bello couldn't come to a conclusion as to John's manner of death. And he pointed out that Dr. Sheridan and Dr. Russell both pointed to the injuries on John's arm and said that's an animal attack, not a collision with a car. And as for the head injury, he said that Dr. Sheridan said that this was consistent with a fight, not a collision. Then Jackson turned to the accident reconstructionist to once again show that John's injuries and the damage to Karen's SUV simply do not match up. So it's just looking at the math and the physics, which many people will generally trust above the testimony of what a person remembered seeing or hearing. This just could not have happened in the way that the Commonwealth said it happened. And to me, that was ending with the defense's strongest arguments possible in this trial. And that's exactly where you want to be ending it, because those are the easiest points of agreement for jurors to make. Remember, I've said throughout this trial that in order to acquit, you don't have to agree with everything that the defense is saying. It's like a target. You have the bullseye, and then you have the bigger circles as you move outward. The argument that Karen Reed was framed by literally everyone in this case, that would be the outermost circle on the target. Then there's the idea that it was maybe not everyone, but the police and the Alberts and the McCabe's, that would be maybe just inside the outer ring. Then you've got the idea that maybe it was just Trooper Proctor and maybe a few of the Alberts and McCabe's or something like that. That's a little further in. And then farther in from there, you have not the framing conspiracy at all, but just the argument that the evidence affirmatively shows that Karen Reed did not hit John O'Keefe and that she actually is innocent. And then you have at the very bullseye of the target, the conclusion that the Commonwealth did not meet its burden of proof. If you conclude anything that lands anywhere on that target, it means acquittal for the defendant, period, end of sentence. And so by ending with the math and the physics and the medicine, which all points to either the idea that Karen affirmatively didn't hit John, or at the very least, the prosecution didn't prove that Karen hit John, that's the easiest for most people to agree on. So ending there in the defense closing argument is very smart because it puts the most likely point of agreement in the most recent part of the juror's memory. Okay, so that's the defense closing argument. Let's talk now about the prosecution's closing argument. Let me start by talking about a number of things that Lally did well during his closing. For one thing, he did start off with more volume and passion than I think we've ever seen him over the last 2 months. And for another, he seemed to start with what may be the strongest point in the Commonwealth's case in chief.
I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag, valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Famati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, "I hit him. I hit him. Oh my God, I hit him." Firefighter Katie McLaughlin was tasked by Firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, "I hit him," repeatedly. Firefighter McLaughlin asked for clarification. "You did what?" And the defendant repeated, "I hit him." Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, "Could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him?" Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, "I hit him." You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, "This is all my fault. This is all my fault. I did this." This is what the defendant is saying on scene. Since then, stories changed a little bit. But those were the words that came from the defendant's mouth on January 29, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case.
However, as you can tell by the end of this clip that just played, the volume and vigor doesn't last long, and the rest of his closing argument was unfortunately in his usual more monotonal style, which can be sometimes difficult to hear. But before I get to more of my criticisms, let me first tell you about the other things I saw that Lally did well in his closing. For one thing, he did bring up the whole Trooper Proctor text messaging situation, and he did say that those were unprofessional, they were terrible, and he shouldn't have done that. And he also said that they didn't have an impact on the investigation as a whole. People can agree or disagree on that, but he made his argument, and that's that. And another thing that Lally said here about those text messages is he said that Trooper Proctor obviously did not intend for anyone to ever see these text messages. So if there was a conspiracy, you would think that he would be talking about it in those texts. And I will say that does not necessarily disprove the entire framing conspiracy argument by the defense, but it is a very good point. Another one that he made at one point was also, why would Brian Alpert drop John O'Keefe off on his own front lawn if he had something to do with his death? But aside from those two things, Lally also had something that he didn't have throughout the trial: visuals. This really was the first time that he really used any kind of visuals like photos and videos and demonstrative timelines to help him as he was going through the material. And anytime that you can give the jury something to look at, it's a good thing for retaining their attention. This is especially true of timelines because they can help you pull pieces of data from different places together into a single narrative. For example, Lally uses date and timestamps from text messages, from surveillance footage, voicemails, and the Toyota text stream data to weave together his timeline. One thing he did effectively was he showed timestamps for each drink Karen drank, according to the Commonwealth anyway. I've said before that I personally have questions as to how many of those drinks we can reliably say had alcohol in them, but regardless, he made the Commonwealth's point effectively with that timeline. And so to the extent that he includes information in the timeline, I think it's a good use. However, I do have some things that I would have wanted to do differently with that timeline if it were my case. For example, he used the timeline for only the beginning portion of his closing argument. That on its own isn't necessarily a bad thing if the rest of the closing argument makes sense to go off from a timeline. But Lally has also had a tendency throughout this trial to do something that I have decided to call not an alley-oop, but a lally-oop. It's where he basically goes over what feels like all of the information in a given setting or a given issue, and then decides to start from the beginning and basically do it all over again, but maybe from a slightly different perspective or with a few tweaks here and there. I talked about this most recently in the Day 28 recap with his direct examination of Dr. Squarty-Bello. And now the problem with the Lally is that when he finishes his first round, it feels like you're about to basically go over the same stuff again when he starts to go through that again. And so the brain has a tendency to want to check out. That's because you feel like, well, okay, I've already heard this. So the problem with that is that if there is actually something important that does come up in that second go round, the person listening might miss it entirely because the brain has been lulled. And this is especially hard when the speaker has a bit of a monotonal delivery of his remarks. Again, if you want to reach and connect with the jury, you're going to have a much harder time doing it if they are unable to pay attention. Now, that issue that I just mentioned about the timeline, that's unfortunately not the only issue that I have with the timeline. Another problem is that there are actually some gaping factual holes in it. And if the jury has been paying attention throughout this trial, generally speaking, and if they're paying attention to that particular timeline, they just might notice these holes. And if they do notice the holes, that can perhaps make them feel like the Commonwealth just isn't giving them the whole story. And given that it is just on the heels of the defense closing, where Jackson's main theme was literally the Commonwealth is telling you to look away and not ask questions, that can be potentially a problem. For example, there are some details that are on the timeline, like Julie Nagel leaving 34 Fairview Road and seeing the black blob on the lawn. But there's nothing else on there showing that anyone else left 34 Fairview Road. And I will say, to me personally, getting reminded of the black blob just reminded me of how no one else seemed to have seen the black blob or even heard her supposedly say something about it in the car. But there's actually a bigger gap in this timeline, and it's what time Karen Read supposedly hit John O'Keefe with her car. You might remember that in his opening statement, Lally said that she hit him at 12:45 a.m. Then, in closing, at one point he suggested that John O'Keefe's phone GPS said that he was hit at 12:25 a.m. since that's the last time that he apparently moved. Then he pointed to the Toyota TechStream data, which said that the second event, the one where Trooper Proctor said that Karen backed up into John going 24 miles per hour, and Lally showed the jury that that happened at 12:30 a.m. So then which one is it? At which time did Karen supposedly hit John? Was it 12:45? Was it 12:25? Was it 12:30? Where a timeline is supposed to clarify things, this one is leaving a very important piece of information from the prosecution's case in chief far deep in the muddy middle. And for one thing, this feels intentionally vague. And for another thing, you know what I say about the muddy middle. Muddy middle means the defense wins. Now, another thing that was a bit perplexing to me about Lally's closing argument was that he instructed the jury at the very beginning to pay attention to the tiny details in the case because they matter. These were things like the fact that Karen didn't take off her shoes when going into John O'Keefe's house. Lally argued that this decision showed Karen is guilty of murder because she knew that John was a huge stickler on cleanliness and she did it anyway. And the reason why she knew that she could get away with wearing her shoes inside the house was because she knew that he was dead. Personally, I think that is a massive stretch, and that requires a huge leap in logic. And I would imagine that even if John were the biggest neat freak stickler in the world, even he would have exceptions for things like emergency situations. For example, if he were outside wearing shoes and he realized that his niece or nephew were in danger inside and he needed to respond, I doubt that he would stop to take his shoes off first before responding to the danger. But even aside from that, there's another alternative explanation for Karen not taking off her shoes that to me seems more plausible than what the prosecution said. She may not have cared because she thought that he was out cheating on her, and so she was really angry at him, so screw his rules about cleanliness in the house. But perhaps the part that was most worthy of critique in Lally's closing argument was the fact that there were two parts where something he said was not in fact backed up by evidence at all. This is not to say that I disagree with his argument about the evidence. I mean to say that there is no testimony to support it, either from the prosecution or the defense. For example, Lally said that on the morning of January 29th, 2022, Karen drove to the Waterfall Bar and Grill by herself, and also in between the waterfall and then driving to Jem McCabe's house. Lally says that she also stopped at 34 Fairview Road so that she could make sure that John's body was still there, ready to be discovered. Let me tell you, I remember clearly the testimony of most of the Commonwealth's digital forensic experts, and particularly about the cell phone towers pinging on Karen's phone. And I also remember the surveillance footage capturing her SUV driving by. There was nothing, absolutely nothing in any of the evidence to suggest that she ever went to 34 Fairview Road between the waterfall and Jem McCabe's house that morning.
No, not this time. It's totally made up. pure fiction. We made this one up. It's a made-up tale.
Now, the other thing that is a huge gap here has to do with the most central question in this trial. Did Karen Reed's SUV hit John O'Keefe? Like I said earlier in this video, this was the anchor to the defense's closing argument, and it was their strongest point. And in the Commonwealth's closing argument, Lally makes no argument from the evidence about any of John's specific injuries matching up with any of the damage to Karen's car, with one exception. He doesn't say anything about Dr. Scorty-Bell's conclusions about the head injury, and he doesn't spend any words on how John got that head injury from the SUV. He also doesn't spend a single word explaining how John ended up in the place he did on January 29th, 2022. He does, however, say one thing about the injuries on John's arm. And this is where he once again pulls something out of thin air that was not testified to by anyone in the trial. Specifically, he says that John's arm abrasions were caused specifically by the particular piece of taillight from Karen's car that had what he called dimples on it, little raised bumps to give the taillight texture from the inside so that the lighting has a certain texture. Now, there were witnesses who testified to seeing this piece of taillight. And I remember wondering throughout this trial why he kept focusing on that particular piece, because it never seemed to be tied to anything during the testimony. But he never asked anyone, especially the medical examiner, Dr. Scorty-Bello, his own witness, whether those abrasions could have been caused by that dimpling. And yet, here's what he said during his closing argument.
The forensic testimony that you have, in regard to the medical testimony, you have the sort of pattern abrasions, clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday, 12 inches and then 6 inches for the tail end, is easily solved by this. And the dimples on his arm are, that I would submit are consistent with the dimples on the taillight cover piece, are right around this area of the elbow.
But that's not the only problem with what he said. Let's take a look at a very specific portion of that last statement that I just played.
No one, not Trooper Paul, not anyone, at any point in time ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air.
The problem for Lally here is on day 26 of the trial, Trooper Paul is on the record showing us otherwise.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, what do you mean? It gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
It, based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm on a hinge? Was it in front of him? You did the reconstruction?
It
Here's exactly how his body was positioned when he was struck by that.
So it looks like his arm was more kind of like this, if I can try to get that.
Now, does the jury remember these details? Maybe. They've been able to take notes throughout the trial, and they have been allowed to bring those notes in with them during these deliberations. So I would imagine that someone would have written that down in their notes somewhere, but we'll see. Overall, I'm sorry to say, I know I've been really ragging on Lally throughout this entire trial. And to be fair,
It sounds like to be fair.
To be fair.
Well, to be fair,
at the end of the day, I am a lawyer sitting and commenting on the real hard work being done here. Regardless of what I think, at the end of the day, he is also the one who is in the ring, knowing that all of his work is getting dissected by the public. Now, with that said, I will still have my opinions of that work. And when that work falls short of what the public, the defendant, and the judicial system deserve, I will say so. This is especially because he is the attorney in the room that is representing the government, and we should absolutely have high standards of that person standing in that role. And here, I think Lally's closing argument left a lot to be desired. But those are my thoughts. What do you think? Do you think I'm being unfair to Lally somehow in my commentary on his closing argument, or maybe in his performance overall during the trial? Do you think that there were things that I didn't talk about which were negative spots in Jackson's closing? What do you think about this trial as a whole, as everything laid out in the end? Let us know your thoughts in the comments down below. I want to thank you once again for joining me on this long journey throughout this trial. And I hope to continue seeing you on this channel as we go down many more paths through many more trials and other legal topics. But otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of interesting legal topics like this, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. And if you really want to support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon. And doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one, as well as other interesting and meaningful legal topics. Links to both are in the description below. Otherwise, see you in the next video.